Okay, the gentleman in jail room 2 that just came into the meeting, can you tell me your name?
Deshaun Parrish.
Okay, 1 second. Mr. Murphy, do you need a breakout session with Mr. Parrish?
If I could, please, Your Honor.
1 second. And the gentleman at the MDOC facility, can you tell me your name, please?
Juwan Williams.
Sorry, I wasn't able to hear you.
Juwan Williams.
Okay, Ms. Underwood, do you need a breakout session with Mr. Williams?
Yes, I do, Your Honor.
All right, I have a Lenawee jail Zoom device logged into the meeting. The camera is off and the microphone is muted. If there's someone there, you need to turn on the camera and unmute the device, please. Okay, the gentleman at the Lenawee County Jail, you're Mr. Goebel?
Are you talking to me?
Yes, are you Mr. Goebel?
Yes, could you please turn up the volume a little?
I can't affect the volume on your side.
Okay. Let me check with the guard.
Okay. Mr. Malero, are you going to need a breakout session with Mr. Goebel?
Just real brief, Judge.
I'm sorry? What?
Go ahead, Mr. Goebel, and get the guard to deal with the volume issue. I was just talking to your attorney.
Could you turn up the volume just once, please? Oh. You turn up the volume on the system. Okay.
All right, Mr. Goebel, I'm going to put you in a breakout session with Mr. Malero.
Thank you, Judge.
This is file 24-22027-FH, People of the State of Michigan versus Juwan Williams. We are here today for a pretrial conference in this case. We are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Sneed?
Isaac Sneed for the people.
Ron Underwood for Mr. Williams this morning, Your Honor. Thank you.
All right, and Ms. Underwood, where do we stand with Mr. Williams' case today?
Your Honor, Mr. Williams' case today, the plea offer from Mr. Sneed is Mr. Williams is charged with 3 counts of assault of a prison employee with a habitual offender force status, Your Honor. The plea offer is Mr. Williams can plead to 1 count, and the last 2 counts and the habitual offender status would be just 4 would be supplements would be dismissed. I believe Mr. Williams wishes to take that offer, Your Honor. And so if we could do, I think we probably need a plea form.
Okay, Mr. Sneed, is that a complete and accurate statement of the plea agreement?
Yes, Your Honor. I just learned that this morning, so I can prepare a plea form.
Right. You want to proceed with it now, or do you want me to wait till we have that form?
I'm prepared to proceed now, Your Honor. Thank you.
Okay. Mr. Williams, would you raise your right hand, please?
I cannot right now. I'm cuffed behind my back.
Okay. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Jawan Alexan Williams?
Yes.
Mr. Williams, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to 1 count of assault of a prison employee?
Yes.
Are you satisfied with Ms. Underwood and the advice she's giving?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 5 years in prison and or a $2,500 fine?
Yes.
Neither the prosecutor, defense attorney, defendant, or anyone acting on defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Sneed?
Yes, Your Honor.
Ms. Underwood?
That's correct, Your Honor.
Is that also your understanding, Mr. Williams?
Yes.
If a guilty plea is accepted, there'll be no trial. It means you're giving up the rights you've had at trial. I'm going to explain those to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You also have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Williams, if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of your rights?
No.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead then to the charge that on or about September 4th, 2024 in Madison Township, Lenawee County, Michigan, that you did commit the offense of assault of a prison employee?
Guilty.
Has anybody made any threats or promises to you to induce you to plead guilty?
No.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Williams to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Williams, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yes.
Ms. Underwood, do you want to cover the factual basis?
Yes, Your Honor. Thank you. Mr. Williams, back on September 4th, 2024, were you in the Gus Harrison facility located in Madison Township, Lenawee County, state of Michigan?
Yes.
And you were a prisoner lawfully detained in that facility, correct?
Yes.
And did you come into contact with Augusta Tyndall, an employee of the prison?
Yes.
And that person was within their employment in the prison?
Yes.
And you knew they were an employee of the prison?
Yes.
And did you assault Officer Tyndall by attempting to hit them?
Yes.
And you knew that was an assault and you were not given permission to hit Officer Tyndall?
Yes.
I believe the facts are sufficient, Your Honor.
Mr. Sneed, are the people satisfied?
Yes, thank you, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, thank you, Your Honor.
It
Ms.
has,
Underwood?
Your Honor.
All right, I'll accept the plea that it's been given understandably, voluntarily, and accurately. Mr. Williams has had full knowledge of his rights and he has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for January 17th at 8:15 a.m.
That's January 5th, Your Honor?
January 17th. Mr. Williams, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Okay.
All right, so you are all set then. Mr. Williams, you can let the officer with you know that you're done with court for today.
Okay.
I'm sorry, what is that sentencing date again, Your Honor?
January 17th, 1/7.
17th? Okay,
Correct.
thank you.
Yeah.
Okay, we can go back to Ms. Crabtree. All right, we are back in the record in file 22-20733-FH, People versus Leanne Rosanna Crabtree. Mr. Grimm has had an opportunity to speak to Ms. Teskey. So where do we stand with the case at this point?
Well, Your Honor, she is doing some checking on the time that she has served and some other information, getting her file together. He was going to send me a message and let me know what the outcome of that was. So I guess we're still in limbo until she comes back on.
Your Honor,
Oh, there we are.
Yes.
I am waiting to hear from Jackson County Jail. What I have proposed to Mr. Grimm is I am not opposed to revoking probation today if she waives her right to an updated pre-sentence investigation report. And give her a year jail with credit for time served. The problem is I'm trying to figure out the credit for time served because she's been, I don't know the date that she got arrested in Jackson County.
June 27th.
What date?
June 27th.
Is there anybody there with you to verify that, Ms. Crabtree?
Hold on one moment. I'm sorry, it might be loud.
So, Judge, if you're on board with that, I'm not opposed to that.
Fine.
All
Leanne,
right.
just tell them Leanne, just
Yes.
tell them I'm having a hard time getting a live body on the phone. I've tried.
Okay, hold on. I'm gonna mute this real quick so I can yell, okay?
Okay. Okay, Mr. Murphy, are you ready to proceed with Mr. Parrish?
Yes, Your Honor.
All right. We are on the record in file 24-21846-FH People versus Deshaun Michael Parrish. We are here today for a final pretrial conference in this case. We are proceeding today by video conference. First name of the attorney's place their appearance on the record, beginning with Mr. Bayoneto.
Alex Bayoneto for the people.
Matthew Murphy, appearing on behalf of Mr. Parrish.
All right, and Mr. Murphy, where do we stand with Mr. Parrish's case today?
Your Honor, as you can tell, Mr. Parrish is currently incarcerated in Hillsdale County Jail. There was a case that he's been charged with out there. He is going to be in custody. He has a bond. He's not able to post. He's going to be in custody at least until December 11th in Hillsdale County. Now, in regards to this matter, we do have trial set, I believe, for the 10th and the 11th. Mr. Parrish's case, from my docket, it appears to be the oldest file that I have down, and would be the one going to trial. Now, there is an offer from the people that would involve a misdemeanor with payment of restitution and any further information Mr. Parrish could provide. Now, in regards to the trial, I do have an issue with Mr. Parrish being in custody. It was not anticipated by myself to have him in custody. I didn't want him to appear in his jail outfit. So Mr. Parrish was asking that as well. He has concern about that. He was asking if the court would be willing to adjourn the trial because of the issue with his current pending case out in Hillsdale. And because of that pending case, the offer from the prosecution is being reconsidered at this point. We may have a resolution based upon, again, the issues with Hillsdale and this case. So at this point, that's what we're asking. If Mr. Bayoneto objects, then obviously we'll leave it to the court. But that's what I just wanted to inform the court of that, and that's what we're asking for. We do, I guess, adjourn the trial, maybe set another pretrial 2 or 3 weeks or whatever the court could find in its schedule.
All right, Mr. Bayoneto, we have any input?
Your Honor, I don't have an objection to an adjournment of the trial. I actually had the victims in here in my office yesterday, and we talked about that being a possibility given this new case that popped up. It may affect the guidelines as well, so that's something we would need to explore. So if the court is willing to adjourn, the people have no objection to that.
What are the new charges in Hillsdale, Mr. Murphy? Do you know?
He's facing an OWI. I believe that's a first offense, right, Mr. Parrish, a misdemeanor?
Yeah.
And he's facing, I believe, 4 counts of resisting opposing officers. He believes they're without injury, the 2 years, but I'm not 100% sure on that. But he said there's 4 counts of resisting opposing officer and the OWI.
Okay, it does appear, I do think there's good cause for this adjournment. Obviously, Mr. Parrish being incarcerated adversely impacts Mr. Murphy's ability to prepare for a trial. So what I will do is set this for a pretrial on December 18th. And hopefully that'll give parties an opportunity to explore any changes to a potential resolution of the matter. If not, we'll reschedule it for trial at that time.
Yes, Your Honor. And my office will do the stipulation in order for that date, December 18th.
Okay, thank you. Then, Mr. Murphy, is there anything else we need to address with this case today?
No, Your Honor.
Nothing on the record. I'll talk to Mr. Barnett probably later today about some stuff then.
Okay, thank you, Mr. Parrish. You can let the officers with you know that you're done with court for today.
Thank you.
Thank you, Mr. Parrish. You have a good day, okay?
Yeah, you guys too.
Okay.
Who was the judge?
Yeah. The my probation officer and the judge. I don't know what just happened.
Sure.
Don't do that. What is that? Breakout or something?
They're sending you back to the court.
Oh, okay. She said she's having a problem trying to get hold of somebody here. Go figure.
Miss Crabtree,
Yes, he's right here.
before he calls another case, I'll just verify those dates.
Okay.
Sir, can
Yes,
you
ma'am.
verify that she's been in jail in Jackson County Jail since 6/27/24?
Yes, ma'am. She was booked in on the 25th, 6/25.
Oh, 6/25. Okay.
Yep.
All right. Thank you so much.
Yes, ma'am.
Thank you.
Mr. Murphy, I believe Mr. Gritzmaker is here in the courtroom. Do you need to speak to him?
I will, Your Honor.
Give me just a second. I gotta reset the breakout rooms. Mr. Gritzmaker, if you want to step out to the hallway, I'll bring the iPad in and you can speak to Mr. Murphy.
So, okay, thank you.
All right, Mr. Case, if you're there, I need you to unmute your device.
Okay. Is that better?
It's still pretty bad. Ms. Underwood, are you able to hear him?
I actually am, Your Honor.
Okay. And, okay, so we can go on the record. This is file 24-21827-FH People versus Jeffrey Patrick Case. We're here today for a pretrial conference in this matter, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Burke?
Your Honor, thank you. Good morning. For the record, my name is Mark Burke. My P number is 54935 with the Attorney General's Office for the people.
Rhonda Underwood for Mr. Case this morning, Your Honor.
All right, and Ms. Underwood, where do we stand with Mr. Case's case today?
Thank you, Your Honor. Mr. Case paid a very large bond earlier this year, Your Honor. But he's had some injuries, so payments have been spotty. I talked to the Attorney General's office, and they are willing to give Mr. Case a 60-day adjournment, but Mr. Case should be aware that he really needs to step up payments and get moving on this. So we would ask,
okay,
and I don't believe the Attorney General's office would object to a 60-day adjournment, Your Honor.
all right. Is that accurate, Mr. Burke?
It is, Your Honor. Yes, we have no problem with an adjournment. Again, as Ms. Underwood indicated, the defendant needs to continue making payments. The good news is he does not have a current support obligation, but his arrearage is in excess of $42,000. So he's gotta start chipping away at that. So no objection to the 60-day adjournment, Judge. Thank you.
Right, so 60 days would take us to about February 5th.
Thank you, Your Honor.
I will set it for February 5th at 8:15 a.m.
That's good for the people, Judge. Thank you very much.
Thank you, Your Honor.
Ms. Underwood, would you do that stip in order?
I would be more than happy with Mr. Burke's permission.
Absolutely. Ms. Underwood, do you need my P number for that?
Yes, please.
It's 54935. And you're welcome to sign my name with consent.
35,
Sorry, 54935.
65.
No, 54935.
549356.
Correct. No 6.
No 6.
Right.
Oh, thank you.
No problem. No problem. Your Honor, thank you very much. Have a great day.
Okay, thank you. Mr. Case, again, your next date will be February 5th at 8:15. You need to log back in with the same Zoom information you used today. Do you understand that?
Yes, Your Honor. Thank you.
Okay, you can go ahead and log out then.
All right. Thank you.
Thank you, Your Honor. Have a great day.
Thank you, Mr. Burke.
Thank you.
Thank you, Ms. Underwood.
Ms. Underwood, I have Mr. Ryan here. Do you need to speak to him?
No, I don't believe I do, Your Honor.
Okay, let me get to Mr. Goebel first. Mr. Malero, are you ready to proceed with Mr. Goebel?
I am, Your Honor.
All right. On the record in files 24-21915-FH and 24-21916-FH, People versus Michael Ronald Goebel. We are here today for a pretrial conference in both of these cases, and we are proceeding today by Zoom video conference. First, let me have the attorneys place their appearance on the record, beginning with Mr. Bayonetto.
Alex Bayonetto filling in for prosecutor of record Phoebe McClure for the people.
Salvatore Malero on behalf of the defendant.
All right, and Mr. Malero, where do we stand with Mr. Goebel's cases today?
Judges, the court is aware, Mrs. McClure has a personal situation that she's dealing with. So I'd ask to adjourn this matter 30 days for her and I to get together and see exactly what we can do to resolve these matters. That's my request.
All right, Mr. Bayonet, is there anything that we need to address from the people's side?
No, Your Honor.
All right, so I am aware that Ms. McClure is not available today and that that was unexpected, so we can adjourn this to January 8th at 8:15 a.m. I will say at that point, the case is going to be about 135, 140 days past bind over at that point. So I'd probably be looking at setting it for a trial at that point if we have not resolved the matter at that time.
Understood, Your Honor.
Understood, Judge.
Mr. Malero, would you be willing to do the stipulation in order for the adjournment?
Yes, I will.
Okay. All right, Mr. Goebel, your next date is going to be January 8th. You can let the officer with you know that you're done with court for today.
Okay.
Thank you, Judge.
Thank you. Mr. Murphy, are you ready to proceed with Mr. Gritzmaker?
I think so, Your Honor. I guess I had to ask Your Honor some questions because Mr. Gritzmaker had said that someone had talked to you, or he thought someone had talked to you. So,
Okay, well, let me call the case. Mr. Gritzmaker, you want to come forward? This is file 24-21843-FH People versus Keith Dwayne Gritzmaker. We are here today for a final pretrial conference in this case, and we are proceeding today by video conference and in person. Mr. Gritzmaker is here in the courtroom in person. First, can I have the attorneys place their appearances on the record, beginning with Mr. Bayonetto.
Alex Bayonetto for the people.
Matthew Murphy, appearing on behalf of Mr. Gritzmaker.
All right, and so again, this is a final pretrial. We have a trial scheduled for December 10th. So Mr. Murphy, where do we stand today?
Your Honor, with Mr. Gritzmaker's case, there's been, we're trying to have him enter into sobriety court. There was some issues with that being conveyed. When we had him screened, there was some miscommunication with the sobriety court coordinator relaying to us the results of that, as well as further steps that Mr. Gritzmaker had to make. So ultimately, the process has been quite delayed. And then I got an email on Monday from the sobriety court coordinator indicating that their good practices time frame was not met, and they weren't going to let Mr. Gritzmaker in to sobriety court. And so that's what I talked to Mr. Gritzmaker about that yesterday. This morning, he had said that he talked to someone named Stacy from the sobriety court, and that someone had spoken to you, maybe that it was Miss Cannon. I don't know if Your Honor had spoken to anyone, or if anyone tried to speak to Your Honor about Mr. Gritzmaker's case. The issue here being, obviously, I don't know. The last information I have is that he can't go into sobriety court. Our intention was, there was an offer from the prosecution that we're trying to get that hammered down as well. Even with him being accepted into sobriety court, there wasn't an offer in place that we could accept. All he could have done was just plead as charged. Now, Mr. Bayonetto has extended an offer that would involve him pleading to an OWI third, a felony, dropping off the habitual offender status, and suspending any jail time that would be applicable. Again, there's 30 days that's applicable under the statute, suspending 6 months of jail time with entrance into sobriety court. Mr. Gritzmaker wants to plead, but he wants to go into sobriety court. So I guess did Your Honor have any conversation with Ms. Cannon or anyone about Mr. Gritzmaker's case?
I've not had any conversations with anyone.
At this point, I have a concern because from my understanding, there's no offer in place at this point then, correct, Mr. Bayanetto? Because there's no guarantee, or he's not, I don't have any information about him going into sobriety court.
I mean, I guess that would be correct statutorily. There is mandatory jail time unless the defendant is going to participate in a specialty court program. So if he can't participate in sobriety court, then we can't suspend jail time. I would agree to the mandatory minimum jail time, but that would be all that I could agree to at this point.
So, Your Honor, I think, judging by my conversation with Mr. Gritzmaker this morning, I have concern about him entering a plea at this point because his understanding is not what my understanding of the situation is. Can we continue the trial on? And if we get this figured out beforehand, we'll contact the court and have it pled out. And if not, I don't know what else that we can do. But there's some issue that we need to figure out here in regards to what his understanding of what sobriety court was telling him. So I guess at this point, that's all I can do at this point. I don't feel comfortable in him entering a plea. I don't think that it's knowingly done. So I guess we'll just continue the trial if we could, Your Honor.
So can I interject just a second? Has he been approved for sobriety court?
Yeah, he was approved, and then I got an email saying that he's not allowed in anymore.
Okay, so he wasn't approved.
He was approved, and then we got an email saying that Mr. Gritzmaker is beyond best practice time frame for sobriety court entrance. He will not be accepted into the program. And that was from Elizabeth Westgate.
Okay.
And I asked for
Judge, would you-
clarification, and she said that as treatment courts are bound by best practices, get audited and lose funding if not followed. Best practices says that reducing the time between the date of offense, sentencing, and initiation in treatment court should be processed and plea taken within 30 days. So that was the last information I got from the sobriety court coordinator.
Would you like me to reach out, Judge?
If that would be helpful. I mean, I guess what I can do right now is leave it on for trial on December 10th. If you can get this issue worked out, just let us know and we'll be happy to take the plea and resolve it that way.
Yeah, if we could please, Your Honor, I don't want to take up any more of the court's time this morning. I mean, we could, if you wanted to set it aside, I don't know, but I didn't want Mr. Gritzmaker to sit around all morning. So if we could just continue the trial, and then I'll speak with sobriety court and whoever I can and get this thing figured out, I guess.
I'm happy to do it either way. Mr. Gritzmaker, if you want to sit around and wait and see if it gets figured out this morning, we can wait and see what happens, or we can, we can try to get it on the docket sometime between now and next week, or whatever.
I mean, we can do the docket another day or whatever, like whatever's more convenient for everybody, because like it's been just a misunderstanding from the get-go, like with you guys communicating and with the sobriety court people and then back and forth, and then judge or my lawyer and us, not being in person every time. Like I read people by their face, so that does a lot. And then I'm just trying to get into sobriety court. If I can reapply, that's what I'm going to try to do. Like I don't know what.
Okay.
Can we,
so I can't control whether you qualify for sobriety court or not. That's a determination that I'm not involved in.
Okay. See, I talked to, I forget, Stacy this morning. She said you talked to Heidi or somebody.
I don't know who Stacy is, and I don't know why she told you that, because I haven't spoken to anyone about your case.
Okay.
Let's just, can we just set it aside to later in the docket this morning? Mr. Gritzmaker, do you want to come over to my office and we can talk as, you know, in between my cases and we can try to figure this out?
Yeah, that's fine.
Can we do that, please, Your Honor?
I get a little bit of clarification, Your Honor. I just spoke to Liz Westgate. When he didn't accept responsibility and he took it to trial, it extended out the time that if he would have taken responsibility and accepted the plea offer on this, and we could have got him going prior to this, then they would have accepted him. As of Monday, Liz said that the judge had decided that he was not eligible for sobriety court at this time.
Okay, so the judge, meaning Judge Shadler, who runs the sobriety court.
Correct.
All right, so perhaps that's the confusion. Someone told Mr. Gritzmaker that they spoke to a judge and it was Judge Shadler. and
Yeah, it's not you. Yeah, it's not you. It's the other judge.
All right, so what we'll do is just leave it on the calendar as it is. If Mr. Murphy and Mr. Bano can work something out, then I'm happy to put it on the docket at any time before the trial to get that resolution placed on the record, but it doesn't sound like that's going to be able to happen today.
Yes, Your Honor. Thank you.
All right, so you're all set. I think you wanted him to come over to your office, Mr. Murphy?
Yes, if you could, Mr. Gritzmaker, you want to come over to my office?
Yeah. And do you get this or him?
I don't know what that
It's
is.
a letter of recommendation from my therapist and all that.
You should give that to Mr. Murphy.
Okay, thank you.
Thank you.
All right, and Ms. Teskey, then are we ready? Do we know what's going on with Ms. Crabtree?
Yeah, sure, Honor.
Okay. So back on the record in file 22-20733-FH, People versus Rosanna Crabtree. So Ms. Teskey, where do we stand then with Ms. Crabtree's situation?
Your Honor, I proposed Attorney Grimm, if the defendant is wanting to be discharged from probation in Lenawee County, she currently has sentencing in January in Jackson County on possession of meth charges, Your Honor. Her guidelines on the new offense are 5 to 23. They're recommending a term of probation up there. On our case, we have 0 to 17 guidelines. She has not ever been compliant on probation since being placed on probation in this county on 10/12 of 23. I'm sorry, 5/4 of 23. She has not been compliant at all. She's violated twice. My recommendation, if the objective here is to have her off probation in Lenawee County, is for her to waive her right to an updated pre-sentence report or a violation report, sentence her to a year jail with credit for 230 days. And revoke probation.
Okay, Mr. Grimm, do you know if that's what Ms. Crabtree wants to do, or do you need to speak to her?
Let me speak to her very briefly, if I may. I think that's where we're going to go, but if I could
Okay,
speak with her, I'd appreciate it.
One moment, I will put you in a breakout session.
Thank you.
Okay, and I'm sorry, the gentleman, your screen name is Dan. You've been logged in since early this morning and we haven't been able to hear you. Are you there?
Yes, I'm here if you can hear me.
Okay, and we do have audio for you now. And so what is your full name?
Daniel Wertz, W-E-R-T-Z.
Okay, and Mr. Dagger Margosi, do you need to speak to Mr. Wertz?
No, Your Honor.
Okay, so we are on the record then in file 24-22064-FH People versus Daniel Charles Wertz. We are here today for an arraignment in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Is it going to be Mr. Sneed or Mr. Bana?
I'll handle it, Judge. Isaac Sneed for the people.
Okay.
Your Honor, Michael
Yeah,
Dagmar for Mr. Wertz.
Okay, thank you. Mr. Dagmar-Gosian, does Mr. Wertz wish to have the information read today?
No, Your Honor.
Okay, and I do have an amended information. Is he going to be entering a plea?
Correct. I have spoken with Mr. Bayonetto on this matter, and we are ready to enter a plea on this case.
Okay, you want to state the terms of that plea agreement on the record, and then I'll ask Mr. Sneed to confirm.
Your Honor, the plea will be to count 2 on the amended information, and in exchange, count 1 would be dismissed. There is no sentencing agreement or anything to that effect. I guess I would ask the court, this is going to be a 90-day misdemeanor, non-abstracted, 0-point offense. I would ask the court if you would consider an immediate sentence. I would imagine it would be, the recommendation would be a fine only. But that would be my recommendation after the plea, or my request after the plea.
All right, Mr. Wertz, would you raise your hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
You are Daniel Charles Wertz.
Yes, I am.
Mr. Wertz, you've heard the statement of your attorney and the prosecuting attorneys that your intention to plead guilty today to count 2 on the amended information, unlawful use of a license plate.
Yes, Your Honor.
Are you satisfied with Mr. Dagmar-Gosian and the advice that he's given?
As long as I stay out of jail, yeah, I agree 100%.
Do you understand the maximum possible penalty for this offense up to 90 days in jail or up to $100 in fines?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with force. Is that correct, Mr. I guess, is this Mr. Bayonetto's case?
Yeah, he did handle it, Judge. Just some confusion
Okay.
because of the arraignment versus the plea taking, but thank you.
Well, Mr. Bayonetto, why don't you place your appearance on the record?
Alex Bayonetto for the people.
And then is it accurate that no one's discussed possible sentence with me?
That's correct, Your Honor.
Mr. Dagmar-Gosian.
Correct, Your Honor.
Is that also your understanding, Mr. Wertz?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Wertz, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application believed to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
I have no questions right now, Your Honor.
And do you understand that you're giving those rights up?
Yes, I do.
How do you wish to plead then to the charge that on or about August 1st, 2024, in the Village of Clinton, County of Lenawee, that you did commit the offense of unlawful use of a license plate?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Wirtz to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. Wirtz, do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
I understand, Your Honor.
Has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yes, sir.
Mr. Dagger-Margosi, do you want to cover the factual basis?
Mr. Wirtz, on the date and time that the judge indicated on August 1st of this year, were you in the Village of Clinton, County of Lenawee, State of Michigan?
Yes, I was.
And on that date, were you operating a motor vehicle?
Yes, I was.
And were you either carrying or did you display on a Ford F-150 a registration certificate that was not assigned to that vehicle?
Yes, I was.
All right. And did you were aware that it was improper?
Yes.
Okay. I'm satisfied, Your Honor.
Mr. Bayonet, are the people satisfied?
Yes, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Mr. Bayonet?
It has, Your Honor.
Yes, Your Honor.
Mr. Dagger-Margosi?
Yes.
All right, I'll accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Wirtz has had full knowledge of his rights. He's had competent counsel. Court's not made any agreement regarding the possibility of a plea or possible sentence in this case with prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. My understanding, Mr. Dagger-Margosi, is that you would like to proceed immediately to sentencing. Is that accurate?
I would ask the court to do so, namely for two reasons, like I indicated previously, what this offense is, but also Mr. Wirtz has a sentencing matter in district court, so he's going to be on probation there. So I think it would be appropriate to move forward with an immediate sentence here.
What's the sentencing in district court?
It's going to be a deferred sentence under on a A and B.
Well, I'm sorry. I meant what is he pled to, or what was the conviction?
A and B under 769.4A on a separate matter.
Mr. Bano, people have any input on that?
Judge, we have no position. I'll leave it to your discretion.
Okay, Mr. Wirtz, are you willing to waive any right to a pre-sentence investigation and report from the probation department and proceed with sentencing?
Yes, Your Honor.
Mr. Dagger-Margosi, is there anything you want to say on behalf of Mr. Wirtz before court passes sentence?
I'll indicate that part of the, and I don't need to go too deep into it, but part of really both of these matters, this one and the one in district court, stemmed from financial issues. So I would just ask the court to take that into account when imposing a sentence. This is a non-assaultive 90-day misdemeanor. I would just ask the court to take that into account.
Mr. Wirtz, is there anything that you would like to say on your own behalf before the court passes sentence?
Not right now, Your Honor. No.
All All right, we sent to the court then that Mr. Wertz pay a fine of $100 payable within 30 days of today's date. Also pay costs, court costs of $750, a state cost of $30, and a crime victims fee of $75. You do have the ability to request an appeal of that sentence, Mr. Wertz. We're going to send to you in the mail 3 copies of the notice of right to appellate review and request for appointment of attorney form. When you get that form, you need to sign 1 copy and return that to us. If you want to appeal your sentence, you need to fill out the remaining portion of that form and mail it to the address listed in the form within 42 days. Do you understand that?
Yes, Your Honor.
Okay, you can go ahead and log out.
And
Thank
Your
you.
Honor, Dan, real quick, Your Honor, that payment can be made to the circuit court clerk's office.
Yeah, that gets paid
Okay.
in the circuit court clerk's office.
So Dan, when you have time, go to the circuit court clerk's office on the 3rd floor at the judicial building. Give me a call afterwards if you need to, okay?
Okay, I'll talk to you later.
Thanks.
All right, Mr. Grimm, are we ready to proceed with Ms. Crabtree then?
I think we are, Your Honor. I just have one question for Ms. Teskey. Does that 230 days does not appear to include the time that she was waiting in Jackson to be transferred to Lenawee?
I think Ms. Teskey stepped out and just walked back into the room.
I'm sorry, Your Honor, I had a parent here.
No problem. Mr. Grimm had a question about the jail credit and go ahead, Ms. Grimm.
Thank you, Your Honor. Ms. Teskey, I'm just curious whether the 230 days credit that you had proffered a bit ago included the time that she waited in the Jackson jail to be transferred to Lenawee at the beginning of this case.
Yes, it has everything in it.
All right, I come up with 290 if it has everything in it. I have 133 days current, 90 days that she was waiting there, and 67 that she served.
Oh, okay, I apologize, Mr. Grimm. I don't have, I can put you in a breakout session, but I can't have you have this conversation on the record here because it brings my docket to a halt and I have people waiting.
I understand that, Your Honor. A breakout would be fine.
Okay, Ms. Underwood, do you need a breakout session with Mr. Ryan?
No, I do not, Your Honor.
Mr. Malero, are you going to need a breakout session with Ms. Betzer?
No, I do. No, I will not, Your Honor. We're ready to
Okay.
proceed.
All right.
Judge, is Miss Ward on by chance? Teresa Ward?
No. No.
Okay.
Okay, Mr. Ryan, if you're there and can hear me, I need you to unmute your device. Okay, we are on the record in file 24-21881-FH, People versus Davian Scott Ryan. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Mr. Bayonet.
Alex Bayanetto for the people.
Ron Underwood for Mr. Ryan this morning, Your Honor. As to Mr. Ryan's case, Your Honor, I spoke with the prosecutor's department yesterday. Mr. Ryan was awaiting new charges, Your Honor, and they have just come down. So, and also this is Ms. Mears' case, Ms. McClure's case. So I would ask for a 30-day adjournment, Your Honor, for those charges to proceed, and so we can proceed with updated information as to further proceedings, Your Honor.
Are those charges related to this offense in any way?
I don't believe they're related to this event, Your Honor, but I think they would impact how we're going to proceed. So I want some time for those to proceed and to talk with Ms. McClure about it.
I will adjourn this to January 15th at 8:15 a.m.
And Mr. Bayanetto, I will be more than happy to prepare the stipulation.
Thank you very much.
What date is
At
that
that
again,
point-
Your Honor?
January 15th.
Thank you.
At that point, the case is going to be about 160 days old, and I should anticipate that I would set it for trial at that time if
Thank you.
his issues aren't resolved.
Thank you, Your Honor.
All right, Mr. Ryan, your next date is January 15th at 8:15 a.m. You can log back in with all the same Zoom information that you used today. Do you understand that?
Yes, sir. Thank you.
Okay, so you're all set for today. You can go ahead and log out. All right, Mr. Grimm, are we ready to proceed with Ms. Crabtree?
I think so, Your Honor.
This is file 22-20733-FH, People versus Leanne Rosanna Crabtree. We're back on the record. So, Mr. Grimm, where do we stand with this case at the moment?
All right. Ms. Teskey had indicated the 230 days jail credit. There is some discrepancy of a few days that may not have been credited. However, I would ask that Ms. Crabtree indicates to me that she would be able to pay the fines and costs that have been assessed with this case within 5 days. And I would ask that the judge simply sentence her to time served, the 230 days.
Oh, okay. So I'm just going to interrupt you because we're talking about sentencing before she wants to even tell me whether she's going to plea or not. So she can plead guilty or not guilty. If she pleads guilty today, I'm going to set a sentencing date because there's not an agreement with probation for what the sentence would be. You're asking for something different. So I'll set a sentencing date. We'll have her violation report prepared, and then I'll decide on a sentence at the appropriate time.
I believe that my client would be willing to waive the PSI and go directly to sentencing today.
Sir, I don't have time for that today, and if there's a dispute or a disagreement on what the sentence is going to be, I want to have the report prepared so that I can familiarize myself with the case and the situation, and craft an appropriate sentence.
All right,
Okay.
thank you. Thank you.
So does she want to enter a plea, or does she want me to set it for a hearing?
Guilty.
She'll enter a plea, Your Honor.
All right, Ms. Crabtree, will you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Leanne Rosanna Crabtree, correct?
Yes, sir.
Do you understand that you have a right to contest this violation of probation charge and to have a trial on it?
Yes, I do.
Do you understand that you also have a right to contest the contempt for failure to appear and to have a trial on that?
Yes.
Do you understand that throughout the trial, you'd be presumed innocent until your guilt is proven by a preponderance of evidence with respect to the violation of probation, and beyond a reasonable doubt with respect to the contempt for failing to appear?
Yes.
You have the right to have all the witnesses against you appear at your trial. You or your lawyer can ask those witnesses questions. You also have the right to have any order, any witnesses you have for your defense to appear at your trial. Do you understand all of that?
Yes.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes.
On the other hand, you have the right to testify if you wanted to testify. Do you understand that as well?
Yes.
How do you plead to the charge that you violated your probation by failing to complete the Hope House program?
Guilty.
And how do you plead to the charge that you failed to appear for a violation of probation summons on January 31st, 2024?
Guilty.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes, sir.
Has anything been promised to you in order to get you to plead guilty today?
No, sir.
Has anybody threatened you in any way in order to get you to plead guilty today?
No, sir.
If I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter that plea. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty today?
Yes.
So you were placed on probation in this case back in 2022, is that correct?
Yes, sir.
And you had had a couple other violations, and eventually it became a part of your probation that you were required to complete the Hope House residential treatment program, is that correct?
Yes, it is.
And you went into that program, but you left before you completed it on January 3rd of 2024, is that correct?
Yes, it is.
And as a result of that, the court sent out a summons for a probation violation, scheduling a hearing for January 31st, 2024. And you did not appear here in court or by Zoom for that hearing. Is that correct?
That's correct.
All right, I will accept the pleas. They've been given understandably, voluntarily, and accurately. Ms. Crabtree has had competent counsel, and she has had full knowledge of her rights. I will refer this to the probation department for an update of your pre-sentence investigation. And set sentencing for December 20th at 8:15 a.m.
Your Honor,
And
you
you will
said
still-
December 28th,
20th,
20th. Okay,
20.
thank you. Sorry.
Okay, and you will still be in Jackson, is that correct? Because that's before your
Yes.
sentencing date. Okay, so
Yes.
we will make arrangements with the Jackson County Jail to have you appear by Zoom for that hearing. Unless you do have the right to be present in person in the courtroom, you would need to waive that right if you wanted to do it by Zoom video conference.
I'll do it by Zoom.
Okay. All right, so we'll see you back in a couple weeks for sentencing. Mr. Grimm, is there anything else we need to address today?
I don't believe so, and I believe the warrant would be lifted from her. Is that correct?
Yes, we will have that warrant recalled and taken out of lien.
Thank you very much. I don't believe I have anything else. Thank you.
Okay, thank you very much. You can log out.
Thank you.
Thank you. Thank you.
Okay, Mr. Murphy, do you need to speak to Mr. Lamley?
I don't, Your Honor.
All right, this is file 24-22063-FH People versus Noah Lamley. We're here today for an arraignment in this case. We are proceeding today by video conference. First hand, the attorneys place their appearance on the record, beginning with Mr. Bayonetta.
Alex Bayonetta for the people.
Matthew Murphy, appearing by Mr. Lamley.
And Mr. Murphy, does Mr. Lamley wish to have the information read this morning?
No, Your Honor, we would waive a reading of the information. We acknowledge receipt of said information, the witness list, and the discovery demand from the prosecution in this matter. We would ask just for an entrance and continuation of a not guilty plea and setting for a pretrial, and we're just asking if we could briefly address bond in this matter too.
Enter a not guilty plea for Mr. Lamley and set a pretrial for. Oh, I'm sorry, this is Judge Angelo's case. Let me find what I have for Judge Angelo. Set a pretrial for January 8th at 8:30 a.m.
Thank you, Your Honor.
All right, and what is it you want to address about bond?
Your Honor, Mr. Lamley has been in custody since September 3rd, I believe. We did have a forensic evaluation done. He was deemed to be competent. That was because about a year ago or a little over a year ago, we had another case where he was determined to be incompetent. During the evaluation for his competency, again, he is taking medication. He is dealing with his issues. This is a destruction of property. He isn't trying to diminish that, but because of the fact that it's destruction of property, a plea agreement would involve, or had involved, talks of plea agreement had involved paying of restitution. Mr. Lamley is asking this court to consider a PR bond in this matter. Obviously, without him being out and trying to make money, he would have no ability to make that restitution and pay any money back. This is involving destruction of property at the public library, I believe. I don't believe he's a flight risk, and I do believe, given the situation, again, he is in a better position now than he was last year. I don't believe he's going to flee, and he wants to get these things taken care of. Again, that's one of the reasons we're asking for this, is for him to try to make money and pay the restitution in this matters. So he's asking the court to consider a PR bond. Thank you.
Mr. Bayonetto, people have any position on that?
Ultimately, I will defer to Your Honor's discretion. However, I am familiar with Mr. Lamley. I had him for a few misdemeanors downstairs, including the one in which he was deemed incompetent. My only concern would be, Your Honor, while I don't believe Mr. Lamley would be a flight risk in the sense that he would flee the county, Mr. Lamley has a history of failing to appear for his cases. I think he did it a few times in his cases downstairs, and he also failed to appear previously in this case. So I believe we're still awaiting criminal responsibility in this case, but I do have some concerns that Mr. Lamley would not show for his next court date. Your Honor, I would also add that bond was addressed already in this case after Mr. Lamley failed to appear, and there was no reduction granted.
Your Honor, if I may, again, we waited until after he had the forensic evaluation done. I believe his failure to appear may have an issue, or I don't believe. I think that they're stemming from his mental health issues that I think are being taken care of. He's on top of dealing with that. He does suffer from blackouts. Is one of the issues that obviously would have a problem with a person keeping track of dates. But I believe, again, from my understanding, reading through the forensic report, I believe that he is taking care of those issues, and that that should take care of his losing the dates. So I would ask the court again. We ask the court to consider a PR bond.
So according to the computer system in my review of the file, he has a $5,000 personal recognizance bond that on the underlying charge, and then a $50 cash or surety bond on a contempt of court. I think based on what I've heard today, that Mr. Lamley's mental health condition is currently being managed medically. I think I'm satisfied that the $50 cash or surety bond on the contempt of court is not necessary at this point. So I would convert that to a personal recognizance bond as well.
Thank you, Your Honor.
All right, so Mr. Lamley, your next court date is January 8th at 8:30 with Judge Anzalone. It's obviously important that you show up for that, because if you don't, you're going to find yourself back in the situation you are now, and it's going to be less likely that you get out again in the future, okay?
Yes, sir. Thank you, sir.
All right, so you're all set. You can let the officer with you know that you're done with court for today.
Thank you, sir. You have a good day.
Mr. Lamley, can you just contact my office sometime next week, please?
No problem, sir.
Thank you.
Okay, Mr. Blair, are you ready to proceed with Ms. Betzer?
Yes, I am, Judge. I'm ready.
Okay, this is file 24-22062-FH and 24-22061-FH, People versus Alexis Marie Betzer. We are here today for arraignment in these cases. We are proceeding today by video conference. First, going to have the attorneys place their appearance on the record, beginning with Mr. Vanetto.
Alex Bayanetto for the people.
Salvatore Malero on behalf of Alexis Betzer.
And Mr. Malero, does Ms. Betzer wish to have the information read this morning?
Your Honor, as to both files, we would waive reading of the information, knowledge of receipt in open court, waive any defects in time and place of service. We further would acknowledge receipt of the witness list on both cases. Ms. Betzer will stand mute and ask the court to enter not guilty plea. And we'd ask the court to set this matter for a pretrial.
Okay, I'll enter not guilty pleas in both files for Ms. Betzer, and we can set a pretrial for, let's go with January 15th at 8:15 a.m.
Judge, Ms. Betzer is currently on bond where she's to do 1 time a week drug testing. It is my understanding she is at Dawn Farms. If I could get a breakout session with her when you're done.
Okay. Is there anything else we need to address today, Mr. Malero or Mr. Bandetto?
I don't believe so, Your Honor.
I do not believe at this time, but Judge, just so the court is aware, Ms. Betzer is being transferred. Where are you being transferred to, Ms. Betzer?
Home of New Vision, it's right in Ann Arbor, so it's not
Home
far
of New
from here.
Vision. Is not related to anything related to her not complying with treatment. It's just they're transferring her. But the court should be aware of that in case they need to get a hold of her, and Mr. Coast as well.
Thank you.
Okay, so I'll put Ms. Betzer, I'm going to put you and Mr. Coast in a breakout session so he can get some information from you.
Judge, may I also go into that breakout?
Sure. Ms. Underwood, do you need to speak to Mr. Shelton?
No, because
I do. Thank you, Your Honor.
Okay, Mr. Shelton, I'm going to put you in a breakout session with Ms. Underwood, if you give me just a moment.
Okay.
Mr. Shelton, are you driving a car right now?
No, I'm outside of work.
Okay, just making sure. Give me just a second here.
All right.
Mr. Murphy, are you going to need to speak to Mr. Underwood?
Just briefly, Your Honor, I think we're ready to proceed with the pleas.
Okay, Mr. Underwood, are you there?
Sir.
Okay, Mr. Underwood, I'm going to put you in a breakout session with your attorney. If you can just a second here.
Yes, sir.
I have a question. Can I leave the courtroom? Sorry.
Yep, you can go.
Okay, thank you.
Mr. Dagger Margosian, I have Mr. Reese here in the courtroom. Do you need to speak to him?
No, Your Honor.
Okay, Mr. Reese, you want to come forward to the podium? Okay, this is file 24-21887-FH People versus Mark Anthony Reese. We are here today for a final pretrial hearing in this case. We are proceeding today partially in person and partially by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bandetto.
Alex Bayonetto for the people.
Your Honor, Michael Dagger Margosian for Mr. Reese.
Okay, and Mr. Dagger Margosian, where do we stand with Mr. Reese's case today?
Your Honor, Mr. Bayanetto and I have reached a resolution. Mr. Reese is going to be entering a plea to count 1. Pursuant to that, counts 2, 3, 4 will be dismissed.
Okay, is the count 1 with the third offense?
It's with the
I'm
third.
sorry, that's, yeah,
But there's no habituals. But yeah, it would be the third offense.
yeah, yeah, okay, I apologize. So, Mr. Bayanetto, is that a complete and accurate statement of the plea agreement?
It is, Your Honor. There is no sentence agreement in the case. The people will take no position as it relates to sentencing. I don't believe restitution is at issue in this case, and I don't believe any other terms of the plea agreement sheet would apply in this case. So I believe that is the full recitation of the plea.
Okay. Mr. Reese, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yeah.
And you are Mark Anthony Reese?
Yeah.
Mr. Reese, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, operating while intoxicated, third offense?
Yes, sir.
Are you satisfied with Mr. Dagger Margosian and the advice that he's given you?
Yeah.
Do you understand that the maximum possible penalty for that offense is a fine of $500 to $5,000 and either 1 to 5 years incarceration or probation with 30 days and 1 year in jail, at least 48 hours to be served consecutively, and 60 to 180 days community service or rehabilitative programs?
Yeah.
Do you also understand that that requires mandatory vehicle immobilization of not less than 1 year or more than 3 years? Neither the prosecutor, defense attorney, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Bayanetto?
That's correct, Your Honor.
Mr. Dagger Margosian?
Correct, Your Honor.
Is that also your understanding, Mr. Reese?
Yeah.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You also have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir.
You also understand that any appeal from conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes.
So essentially that means that you have to ask the Court of Appeals to hear your appeal if you want to make an appeal, and they decide whether or not they're going to even hear it.
Okay.
If you were convicted at a trial, you'd have a right to an appeal, meaning they would have to hear it no matter what. Do you understand the difference?
Okay. Yeah.
Okay. And you understand you're giving up that right to an appeal, and it would be by application. Okay. If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of your rights?
No.
Do you understand that you're giving them up?
Yes.
How do you wish to plead to the charge that on or about June 30, 2024, in the city of Adrian, county of Lenawee, that you did commit the offense of operating while intoxicated, third offense?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
You understand that if I accept your plea, you're giving up and you don't claim that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yeah.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Reese to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. Reese, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, not really, no.
Okay. You understand that regardless of any conversation?
Well, he said he was gonna try to get the minimal, like, okay, but that's it, yeah.
You understand regardless of any conversations you've had with him about what your sentence might be, this is the court's job to decide what the sentence is, and it could be something different than what he's told you or what you've had discussions about.
Yeah.
And you still want to proceed with the entering plea?
Yeah, what goes in?
You want to move forward with the plea? Yeah.
Yeah.
Okay. All right. Is it your own choice to enter this plea?
Yeah.
Mr. Dagger Margozzi, do you want to cover the factual basis?
Mr. Reese, on June 30th of this year, were you in the city of Adrian, County of Lenawee, state of Michigan?
Yeah.
And were you operating a motor vehicle?
Yes.
And before that operation, did you drink alcohol?
Yeah.
And during the time of when you were operating that motor vehicle, you would agree that your blood alcohol content was 0.08 or greater?
Yeah.
Okay, I'm satisfied.
Mr.
Oh, you know what, I'm sorry, just as far as the priors. Mr. Reese, would you agree that you have a prior OWI conviction in 2005 from 2A district court? Would you agree to that?
Yeah.
And another one in 2008 in Alachua County in Florida?
Yeah.
Okay, and then one more in 2021 in Ohio?
Yeah.
Okay, I'm satisfied.
Okay, Mr. Bennett, are the people satisfied?
Yes, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Mr. Bennett?
It has, Your Honor.
Mr. Dagger Margozzi?
Yes, Your Honor.
All right, I'll accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Reese has had full knowledge of his rights and he's had competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for January 23rd at 8:15 a.m. Mr. Reese, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Is that through the mail or?
So they'll actually, if you leave here and step right across the hall, the probation department, they'll have a packet of forms to give you to fill out, and then you'll need to make arrangements with the probation officer to do your interview. I believe you do those in person.
Okay.
And let's see, Mr. Moore, do you need any other information from Mr. Reese at this point?
No, Your Honor. If he just steps over, we'll set him up.
Okay, so you can just step across the hall.
Thank you.
All right, Ms. Underwood, I have Mr. Cherry here in the courtroom. Do you need to speak to him?
I'm sorry, Your Honor.
Oh, I'm sorry. So, Mr. Cherry, you can come forward to the podium, please. Okay, we are on the record in file 22-20683-FH. People versus Paul Edward Cherry. We are here today for a hearing on a summons for probation violation, and we are proceeding today in person. Sir, you are Paul Edward Cherry.
Yes, sir.
And have you received a copy of the request and summons for probation violation?
Yes.
That document alleges that you have failed to comply with the terms of your probation by failing to pay fines, costs, and restitution. You had, in this case, originally been convicted of larceny by conversion of $200 or more, but less than $1,000. And the maximum possible penalty for that offense is up to 1 year in jail and or a $2,000 fine, or 3 times the value of the property that was taken. You are entitled to have an attorney represent you here today and at any other hearings that we have regarding this matter. If you can't afford an attorney, you can tell me that, and I'll appoint one for you from the public defender's office. Do you understand that?
Yes. Do I need an attorney?
Well, my stock answer to that question is, if you're asking that question, the answer is probably yes. So you are right now facing a probation violation. If you were found guilty of that violation, the court could impose an additional sentence to what you already have, that could be anything up to what you were originally facing as a sentence, the maximum sentence for the charge that you were convicted of. So would you like to be represented by an attorney?
Yes.
Do you have the ability to pay for your own?
No.
Okay. So I'll appoint the public defender's office to represent you. If you want to step out to the hallway, there's an iPad out there, and I can have you speak to Ms. Underwood from the public defender's office right now.
Okay.
Ms. Underwood, have you received the information for Mr. Cherry?
I believe I have, Your Honor. Did we want to finish with Mr. Shelton?
Okay, yeah, let me do that. So Mr. Cherry, if you just wait out there for a few minutes, I'm going to do another case that Ms. Underwood has first, and then we'll get back to your case.
Okay.
Okay, this is file 19-19673-FH, People versus Justin Matthew Shelton. We are here today for a hearing on an alleged probation violation. We are proceeding today by video conference. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Shelton today, Your Honor.
And where do we stand with Mr. Shelton's case today?
My apologies, Your Honor. I just received a communication from Mr. Moore. Could I just have a brief breakout with Mr. Shelton?
Okay, 1 second.
Judge, could you possibly call Teresa Ward's case to just issue that bench warrant?
Yeah, I'm sorry. Let me.
That's okay.
Okay, this is file 24-21923-FH, People versus Teresa Lynn Ward. We are here today for a hearing on a summons for probation violation. We are proceeding today by video conference. The courtroom is also open to the public. The record should reflect this matter was set for a hearing this morning at 8:15 a.m. Ms. Ward was ordered to appear She is not present today in the courtroom, and she is not logged into the Zoom session. There is no one in the Zoom waiting room at this point, and Ms. Ward has not been logged in at any point this morning. So I am going to issue a bench warrant for her arrest for the failure to appear. I will set bond on her bench warrant in the amount of $50,000 cash for surety.
Who is that, Your Honor?
Teresa Ward.
Okay. Thank you.
Thank you, Judge.
Yep, thank you. And Ms. Underwood, are we ready to go back to Mr.
Yes.
Shelton?
Yes, we are.
Okay, so back on the record in People versus Justin Matthew Shelton. Ms. Underwood, where do we stand today?
Your Honor, I've spoken with the probation department. Mr. Shelton is at work, but he gets off work at 4 o'clock. He can make a payment of $500 then, or early in the morning, Your Honor. On that basis, we would ask for an adjournment to allow Mr. Shelton to get this paid off.
How much is left to be paid at this point? Do we know?
Your Honor, there is, hold on. $1,494.41. And he is coming up in February, I believe it is, will be in almost a year here pretrial status. So he'll need to take care of that before then, which he said he can. But we haven't had but $50 payment since March of 24.
All right, so Mr. Moore is correct. This original summons goes back to February of this year. So we're coming up on a year of dealing with this. And so I need to either see some progress or set this for a hearing and resolve it one way or the other. So I will grant one more adjournment. This is likely going to be the last adjournment, so I'll set it out to January 15th at 8:15 a.m.
Thank you, Your Honor.
Thank you. Mr. Shelton, drop off a receipt once you pay that.
Okay, sounds great.
Thank you.
No problem.
Okay, Mr. Cherry, are you there?
Yes, sir.
All right, give me 1 second. I'm going to put you in a breakout room with Ms. Underwood.
Okay.
And sir, what case are you here for?
Alejandro Madrid, probation violation.
You can come forward to the, you're going to need to speak to Ms. Underwood, aren't you? Well, wait, you can come forward. Okay, this is file 23-21441-FH People versus Alejandro Luis Madrid. We are here today for a hearing on a summons for probation violation. We are proceeding today in person. Sir, you are Alejandro Luis Madrid.
Yes, sir.
Mr. Madrid, have you received a copy of the summons for probation violation?
Yes, I did.
So that alleges that you violated the terms of your probation by being convicted of retail fraud on November 12th, 2024 in the Lenawee County District Court. In this case, you had previously been convicted of carrying a concealed weapon, and the maximum possible penalty for that offense up to 5 years in prison and or $2,500 in fines. Do you understand all that?
Yes, sir.
You are entitled to be represented by an attorney today and at any other proceedings we have regarding the matter. If you can't afford an attorney, you can tell me that now and I'll appoint one for you at public expense. Do you understand that?
Yes, sir.
Would you like to be represented by an attorney?
Yeah,
You have the ability to pay for your own attorney.
no.
Okay. If you want to take a seat back in the gallery, I will have you speak to Ms. Underwood. I'll appoint public defender's office to represent you. I have you speak to Ms. Underwood as soon as she's available. Okay, Mr. Murphy, you ready to proceed with Mr. Underwood?
Yes, Your Honor.
This is file 24-21704-FH, People versus Eric Underwood. We are here today for a pretrial conference in this case. We are proceeding today by video conference. First, going to have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Matthew Murphy appearing on behalf of Mr. Underwood.
And Mr. Murphy, where do we stand with Mr. Underwood's case today?
Your Honor, we have a plea agreement in place. I just got a copy and signed it. I was going to send it over to the court and to the prosecutor's office. It's for Mr. Underwood to plead no contest to an added count 2 aggravated assault with agreement for no upfront jail. And he wishes, again, he wanted to accept that offer today and go forward with that plea.
Okay. Mr. Sneed, is that a complete and accurate statement of the plea agreement?
Yes, it is, Your Honor.
Mr. Underwood, would you raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I affirm.
And you are Eric Underwood, correct?
Yes, sir.
Mr. Underwood, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2 on the amended information aggravated assault?
No contest.
No. Yes, sir.
I apologize. Is it your intention to plead no contest to that charge?
Sorry.
Yes, sir.
Do you understand the maximum possible penalty for that offense is up to 1 year in jail and or a $1,000 fine?
Yes, sir.
Are you satisfied with Mr. Murphy and the advice that he's giving?
I'm very, yes, sir.
Other than, as we've discussed on the record today, neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Sneed?
Yes, Your Honor.
Mr. Murphy?
That's correct, Your Honor.
Is that also your understanding, Mr. Underwood?
Yes, sir.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You also have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Underwood, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No questions, sir.
Do you understand that you're giving those rights up?
Yes, sir.
How do you wish to plead to the charge that on or about November 30, 2023, in the city of Tecumseh, County of Lenawee, that you did commit the offense of aggravated assault?
No contest, sir.
Has anyone made any threats or promises to you to induce you to plead no contest to that charge?
No one, sir.
Do you understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter that plea?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Underwood to plead no contest?
No, Your Honor.
No, Your Honor.
Mr. Underwood, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've discussed it on the record here today?
Not at all, sir. No, sir.
Is it your own choice to plead no contest today?
Yes, sir.
All right. And Mr. Murphy, how are we establishing the factual basis?
If the people would have no objection, I will place the facts on the record based upon the police report and the complaint and information.
No objection.
Okay, we would stipulate to the following facts and agree that they will be proven beyond a reasonable doubt at a trial if a trial was to have been had. That on November 30th of 2023, Mr. Underwood was indeed in the city of Tecumseh, County of Lenawee, state of Michigan. That on that date and time, he had an interaction with a Miss Misk. I think I pronounced that appropriately, with a Miss Misk. And just for clarification, Your Honor, we're going to have to use the elements of the greater to satisfy the lesser, the elements of the CSC fourth to satisfy the aggravated assault. So again, on that day and time, he did have an interaction with Miss Misk. During that interaction, there was some consensual hugging that occurred, and then Mr. Underwood had taken that consensual hugging and used that to, I guess you would call it, grope or touch in a sexual manner the breast of Miss Misk. That was not with her consent, and again, it was with, you call it coercion or flight, again, under the guise of a hug, and that contact happened. We believe that that would satisfy the elements of the criminal sexual conduct in the fourth degree, and therefore satisfy the aggravated assault.
Mr. Sneed, the people satisfied with the factual basis?
Yes, thank you, Judge.
All right. Has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, thank you.
Mr.
Yes, Your Honor.
All right. I'll accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Underwood has had full knowledge of his rights, and he has had competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as we've discussed on the record here today. I will refer this matter to the district court probation office for a pre-sentence investigation. And we will set sentencing for January 23rd at 8:15 a.m.
Yes, Your Honor. Thank you.
Mr. Underwood, you need to report to the district court probation office, to Mike McCarron in that office on Tuesday, this coming Tuesday, that's December 10th at 8 a.m.
Yes, sir.
All right. Anything else we need to address today, Mr. Murphy or Mr. Sneed?
No, thank you, Your Honor.
No, Your Honor. Mr. Underwood, I'm going to give you a call later today, okay, this afternoon?
Yes, sir.
Thank you, Your Honor.
Okay. Thank you, Mr. Underwood. You can go ahead and log out.
Thank you, sir.
Okay, Ms. Underwood, are you ready to proceed with Mr. Cherry?
Yes, Your Honor. Thank you.
All right, we are back on the record in file 22-20683-FH, People versus Paul Edward Cherry. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Cherry this morning, Your Honor.
And do you know how Mr. Cherry would like to proceed today?
Mr. Cherry has joined us today, Your Honor, and we would ask you to enter a not guilty plea on his behalf to the violation and set this matter for a pretrial, probably the middle of January, if you could, Your Honor. Mr. Cherry is going to make a $200 payment today, and then he's going to work on getting this paid down.
Okay, so let's go with January 22nd at 8:15 a.m.
Thank you, Your Honor.
So, Mr. Chair, your next date is January 22nd at 8:15. You need to be back here in court, or you can attend by Zoom at that time.
Okay. If I may, where do I make payments right here?
Yep, right across the hall in the clerk's office.
Okay.
Your Honor, even though his probation officer is Mr. McCarron?
That's correct.
Okay.
So you can step right across the hall to the clerk's
Okay, I'm
office.
free to go?
Yep.
Thank you, sir.
Okay, and Ms. Underwood, I have Alejandro Madrid is here. I started his arraignment. Do you have his information?
I have information on Madrid and Nolan, Your Honor.
Okay. Mr. Madrid is here and needs to speak to you. So Mr. Madrid, if you'll step outside the door to the iPad, I'll have you speak to Ms. Underwood. Oh, got shut off. Mr. Dagamar, I do have Mr. Snowden here. Do you need to speak to him?
Your Honor, yeah, let me speak with him, if that's okay. Thanks.
Okay, let's see, Mr. Snowden, I need to unmute your device.
Yes, sir.
Send your request to start your video, and then I'm going to put you in a breakout session with Mr. Dagger Margosian.
Yes, sir.
Okay, back on the record in file 23-21441-FH, People versus Alejandro Luis Madrid. Ms. Underwood, do you want to place your appearance on the record?
Ron Underwood for Mr. Madrid this morning, Your Honor.
And do you know how Mr. Madrid would like to proceed today?
Well, Mr. Madrid has not been sentenced on the charge downstairs. I don't know if the probation department up here would prefer to know what's going to happen down there prior to him taking his plea, or
I don't know, appears to be Ms. Holly's case, and she's not logged in today. I don't know, Mr.
No,
Moore,
it's
cover that.
Your Honor, that the case has been transferred back to myself since my return. And yeah, I mean, at this point, because he hasn't pled guilty to the violation, he could plead guilty. He pled guilty downstairs. I don't see why he wouldn't plead guilty to the violation.
right. But I was trying to think in terms of sentencing times and stuff.
No, if you want to push the sentencing out, that's fine with me.
Okay. Then Mr. Madrid will enter a plea today, Your Honor.
Okay, Mr. Madrid, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And Mr. Madrid, do you understand that you have a right to contest the violation of probation and to have a trial on it?
Yes.
Do you understand that throughout that trial, you'd be presumed innocent until your guilt is proven by a preponderance of evidence?
Yes, sir.
You have the right to have all the witnesses against you appear at that trial. You or your lawyer could ask those witnesses questions, and you also have the right to have me order any witnesses you have for your defense to appear at the trial. You understand all of that?
Yes.
You're not required to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. You understand that? On the other hand, you have the right to testify if you wanted to testify. You understand that as well?
Yes.
How do you want to plead to this charge that you violated your probation by being convicted of retail fraud on November 12, 2024?
Guilty.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've just explained?
Yes, sir.
Has anything been promised to you in order to get you to plead guilty?
No.
Have you been threatened in any way in order to get you to plead guilty? If I accept your plea, you're giving up any claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea. Do you understand that? Is it your own choice to plead guilty today?
It is.
So you're placed on probation in this case back in 2023, is that correct?
Yes.
And one of the conditions of your probation was that you not violate any law of any unit of government, is that correct?
Yeah.
And on November 12, 2024, were you convicted of retail fraud in the 2A District Court?
Yes, sir.
Okay. I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Madrid has had full knowledge of his rights and he's had competent counsel. I will refer this matter to the probation department for an update of your pre-sentence investigation. And do you know your sentencing date in district court?
I don't remember. I know I go and meet my probation officer downstairs on Friday.
It's 12/19, Your Honor.
Oh, all right. Okay, let's set the sentencing for January 9th, then at 8:15. So Mr. Madrid, you'll need to be in touch with Mr. Moore to do an update of your pre-sentence investigation and violation report. When you do that interview, please be truthful about this offense and about your background.
Mr. Madrid, come on over to the office.
Okay.
Okay, so you're all set. Thank you.
Thank you.
Okay, so we can call Henderson. This is file 24-22020-FH, People versus Jonathan Craig Henderson. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Matthew Murphy, appearing we have Mr. Henderson.
All right, and record should reflect this was set for hearing this morning 8:15. It's now 10:29. Mr. Henderson is not present in the courtroom. He is not logged into the Zoom session. Mr. Henderson has not been logged into the Zoom session at any point this morning. Mr. Murphy, is there anything you would like to address on the record today?
Your Honor, I do apologize. I'm not sure where Mr. Henderson is. The number I have comes up as not in service currently. I haven't heard from him since we saw him at the district court when I waived his examination for this case. So I'm not sure where he is. I do apologize, Your Honor. Knowing Mr. Henderson, he'll probably appear later today or tomorrow. But I do apologize for his absence.
Judge, we presently have a contempt of court warrant for his arrest. He tested positive for meth and also ecstasy back on 10/3 when he was in bond conditions down at district court. He has not tested since then.
I do see in the files there is a warrant in each file for that failure to test, and he's not here today, so I'm going to issue a bench warrant for the failure to appear, and I would set bond a bench warrant in the amount of $25,000 cash or surety each file.
Yes, Your Honor. Thank you.
Thank you. Mr. Dagger, are you ready to proceed with Mr. Snowden?
Yes, Your Honor. And Your Honor, I should say that this is going to be a HIDA matter. I don't mind, court staff and everybody, if we could just close the Zoom and close the courtroom, if that's okay.
1 second.